Hello everyone and welcome back to part 8 of our deep dive into Babylonia and Assyria. Today we're continuing off with the chapter dealing with the law. Obviously we're going to be talking about the code of Hammurabi and all the rest. So let's begin. Also, I hope you're enjoying the series. As always, if you are, give it a like and subscribe, and then you'll get the update when the next one comes out. We have 2 more parts of this to do. So let us begin. Babylonian law was of early growth. Among the oldest records of the country are the legal cases, abstracts of which have been transcribed for further use. The first law book, in fact, was ascribed to the god of culture, and it was told how he had enacted that the king should deal uprightly and administer justice to his people. If he regard not justice, it is said, the god of destiny, shall change his fortune and replace him by another. But if he have regard to the injunction of the great gods shall establish him in wisdom and knowledge of righteousness. The of the cuneiform text seems to be the Owens of the Chaldean historian Berosus, who is said to have arisen out of the waters of the Persian Gulf, bringing with him the elements of civilization and the codes of laws which were henceforth to prevail in Babylonia. The chief of Owens has perished, but fragments of another and more historical one have been preserved, and in a reading book which was intended to teach the Semitic pupil the ancient language of the Sumerians. The original Sumerian text is given with its Semitic equivalent, as well as a list of technical legal terms. If a son, it is said, denies his father, his hair shall be cut, he shall be put into chains, and sold for silver. If he denies his mother, his hair shall also be cut. City and land shall collect together and put him in prison. If the wife hates her husband and denies him, they shall throw her into the river. If the husband divorces his wife, he must pay her 50 shekels of silver. If a man hires a servant and kills, wounds, or beats, or ill uses him, or makes him ill, he must with his own hand measure out for him each day half a measure of grain. We have already seen that the last regulation was in force up to the latest period of Babylonian history. It betrays a humane spirit in the early legislation and shows that the slave was regarded as something more than mere chattel. It provided against his being overworked. As soon as the slave was rendered unfit for labor by his hirer's fault, the latter was fined, and the fine was exacted as long as the slave continued ill or maimed. The law which pronounced the sentence of death by drowning upon the unfaithful wife was observed as late as the age of Hammurabi. Such, at least, is the evidence of some curious documents, from which we learn that a certain Arad Shamas married a first daughter of Utatu and subsequently a half-sister of his wife. In the contract of marriage, it is stipulated that unfaithfulness to the husband on the part of both the wives would be punished with drowning, on the part of the second only with slavery. On the other hand, he could divorce them on payment of a manay of silver, that is to say, of 30 shekels apiece. Under Nebuchadnezzar, the old power of putting the wife to death in case of adultery was still possessed by the husband. When the wife was of lower rank than himself, and a little better than a concubine, it was a survival of the patria potestas, which had once belonged to him. The wife, who came from a wealthy and respectable family, however, stood on a footing of equality with her husband, and he could not venture to put it in force against her the provisions of the ancient Sumerian law. Babylonian law resembled that of England in being founded upon precedents. The code, which was supposed to have been revealed by or Oannes, belonged to the infancy of Chaldean society and contained only a rudimentary system of legislation. The actual law of the country was a complicated structure, which had been slowly built up by the labors of generations. An abstract was made of every important case that came before the judges, and the decision given in regard to it. These abstracts were carefully preserved and formed the basis of future judgments. The judges before whom the cases were brought were appointed by the king and acted in his place. They sat under a president and were usually 4 or 5 in number. They had to sign their names at the end of their judgments, after which the date of the document was added. It is probable that they went on circuit like Samuel in Israel and the royal judges of Persia. Where foreigners were involved in the case was first tried before special judges, who probably belonged to the same nationalities as the parties to the suit. If one of the latter, however, was a Babylonian, it was afterwards brought again before a native tribunal. Sometimes in such cases a primitive custom was retained of allowing the elders of the city to sit along with the judges and pronounce upon the question in dispute. Thus they represented, to a certain extent, an English jury. Whether they appeared in the case in which Babylonians alone were engaged is quite doubtful. We hear from them only when at least one of the litigants is an Amorite from Canaan. It is therefore possible that their appearance was a concession to Syrian custom. In Babylonia, they had long been superseded by the judges, the royal power having been greater there from the outset than in the more democratic West, and consequently there would have been but little need for their services. If, however, the foreign settlers had been accustomed at home to have their disputes determined by a council of elders, we can understand why they were still allowed in Babylonia to plead before a similar tribunal, though it could do little more than second the decisions of the judges. Plaintiff and defendant pleaded their own cases, which were drawn up in legal form by the clerks of the court. Witnesses were called and examined, and oaths were taken in the names of the gods and the king. Now the king, it must be remembered, was in earlier times himself a god. In latter days, the oaths were usually dropped, and the evidence alone was considered sufficient. Perhaps experience had taught the bench that perjury was not a preventable crime. Each case was tried by a select number of judges, who were especially appointed to inquire into it, as we may gather from a document dated at Babylon on the 6th day of Nisan, in the 17th year of Nebuchadnezzar. These are the judges, it runs, before whom Sapik-Zeri, the son of Zirutu, and Baladu, the son of Nasikatum, the servant of the secretary of the marshlands, have been appeared in their suit regarding a house. The house indeed had been duly sealed by Zirutu, the father of Sapik-Zeri, and given to Baladu. Baladu, however, had come to terms with Sapik-Zeri, and handed over the house to him, and taken the deed from the record office, and had given it to Sapik-Zeri. Nebo Eder Napishti, the prefect of the marshlands, Nebo Susizani, the sub-prefect of the marshlands, Merodach Erba, the mayor of Erech, Imbi Ilhu, priest of Ur, Bel Yubalid, the son of Merodach-Sum-Ibni, the prefect of the western bank, Abda, the son of Subu, the son of Babutu, Mesuzibel, the son of Nadin-Aki, the son of the adopted one, Badnia, the son of Abda, the priest of the temple at Sabdu-Rabu, and Sasmash-Ibni, the priest of Sadurabu. The list of judges shows the civil governors could act as judges, and that the priests were also eligible for the post. Neither the one class nor the other, however, is usually named, and we must conclude, therefore, that though the governor of a province or the mayor of a town had a right to sit on the judicial bench, he did not often avail himself of it. The charge was drawn up in the technical format and attested by witnesses, before it was presented to the court. We have an example of this, dated at Sippara, the 28th day of Adar, in the 8th year of Cyrus as king of Babylon. Nebo-Aki-Bulid, the son of Su, governor of Sakrin, on the 28th day of Adar, the 8th year of Cyrus, king of Babylon and the world, has brought the following charge against Bel-Ubalid, the priest of Sippara. I have taken Nana-Idin, son of Bau-Eres, into my house, because I am your father's brother and the governor of the city. Why then have you lifted up your hand against me? Rimon Sar-Uzur, the son of Nebo-Usezib, Nargia and Erba his brothers, Kutale, the son of Bau-Eres, Bel-Ubadlid, and the son of Barakiel, Bel-Aki-Uzur, the son of Rimon Usalim, and Ikisa-Abu, the son of Shamash Sar-Uzur, have committed a crime by breaking through my door, entering my house, and leaving it again after carrying away a manet of silver. Then come the names of the 5 witnesses and the clerk. A suit might be compromised by the litigants before it came into the court. In the reign of Nebuchadnezzar, a certain Imliah brought witnesses to the door of the house of an official called Bel-Edin, and accused one Arali, the superintendent of the works, of having stolen an overcoat and a loincloth belonging to himself. But it was agreed that there would be no need on the part of the plaintiff to summon witnesses. The stolen goods were returned without recourse to the law. The care taken not to convict without sufficient evidence, and the thoroughness with which each case was investigated, is one of the most striking features in the records of the Babylonian lawsuits which have come down to us. Mention has already been made to the case of a runaway slave, Barakiel, who pretended to be a free citizen, and the adopted son of a Babylonian gentleman. Every effort seems to have been made to get at the truth, and some of the higher officials were associated with the judges before whom the matter was brought. Eventually, cross-examination compelled Barakiel to confess the actual facts. It is noticeable that no torture was used to compel confession. Even though the defendant was not a free citizen, no allusion, in fact, is ever made to torture, whether by the bastinado or otherwise. The evidence of witnesses and the results of cross-examination are alone depended upon for arriving at the truth. In this respect, the legal procedure of Babylonia offers an honorable contrast to that of ancient Greece or Rome, or even of Europe down to the middle of the last century. 2 cases, which were pleaded before in the courts in the reign of Nabonidus, illustrate the carefulness with which the evidence was examined. One of them was a case of false witness. Beli-Litu, the daughter of Bel-Usezib, the wine merchant, gave the following testimony before the judges of Nabonidus, king of Babylon. In the month of Ab, The first year of Nergal-Sharezer, king of Babylon, I sold my slave Bazuzu for 35 shekels of silver to Nebo-Aki-Iddin, the son of Sula of the family of Agibi. But he now asserts that I owed him a debt, and so has not paid me the money. The judges heard the charge, and caused Nebo-Aki-Iddin to be summoned and to appear before them. Nebo-Aki-Iddin produced the contract which he had made with Beli-Litu. He proved that she had received the money, and convinced the judges. And Ziria, Nebo-Sumalisir, and Edilu gave further testimony before the judges that Beli-Litu, their mother, had received the silver. The judges deliberated and condemned Beli-Litu to a fine of 55 shekels, the highest fine that could ever be inflicted upon her, and then gave it to Nebo-Aki-Iddin. It is possible that the prejudice which has always existed against the money-lender may have encouraged Beli-Litu to commit her act of dishonesty and perjury. That the judges should have handed over the fine to the defendant, instead of paying it to the court or putting it into their own pockets, is somewhat remarkable in the history of the law. The second case is that of some Syrians who had settled in Babylonia, and there been naturalized. The official abstract of it is as follows. Bunanitum, the daughter of Karisian, brought the following complaint before the judges of Nabonidus, king of Babylon. Ben-Hadad Nathan, the son of Nikbadu, married me, and received 3½ manes of silver as my dowry, and I bore him a daughter. I and Ben-Hadad Nathan, my husband, traded with the money of my dowry, and we bought together a house standing on 8 roods of the ground, in the district, in the west side of the Euphrates, in the suburb of Borsippa, for 9⅓ manes of silver, as well as an additional 2½ manes, which we received on loan without interest from Edin-Merodach, the son of Ikisa-Ablu, the son of Nur-Sin. And we invested it all in this house. In the 4th year of Nabonidus, king of Babylon, I claimed my dowry from my husband Ben-Hadad Nathan, and he of his own free will gave it to me, under deed and seal, the house in Borsippa, and the 8 roods on which it stood, and assigned it to me forever, stating in the deed he gave to me that the 2½ manes which Ben-Hadad Nathan and Buninatum had received from Edin-Merodach and laid out in buying this house had been their joint property. This deed he sealed and called down in it the curse of the great gods upon whoever should violate it. In the 5th year of Nabonidus, the king of Babylon, I and my husband Ben-Hadad Nathan adopted Ben-Hadad Amara as our son, and subscribed to the deed of adoption, and at the same time we assigned 2 manes, 10 shekels of silver, and the furniture of the house as a dowry for my daughter Nubda. My husband died, and now Akapi Ilu, the son of my father-in-law, has raised a claim to the house on the property which was willed and assigned to me, as well as a claim to Nebo-Nur-Ilani, whom we bought for money through the agency of Nebo-Aki-Iddin. I have brought him before you. Pass judgment. The judges heard their pleas. They read their deeds and contracts with Bunanitum produced in court, and disallowed the claim of Akabi Ilu to the house of Borsippa, which had been assigned to Bunanitum in lieu of her dowry, as well as to Nebo-Nur-Ilani, whom she and her husband had bought, and to the rest of the property of Ben-Hadad Nathan. They confirmed Bunanitum and Ben-Hadad Amara in their titles. It is further added that Idin Merodach should receive in full the sum 2.5 manes which had been given toward the purchase of the house, and that then Punanitum should take in full 3.5 manes, the amount of her dowry, and that part of her property which had not been bequeathed to Nubka. Nebo Nur Ilani was to be given to Nubta in accordance with the will of her father. The following judges were present on the day of this judgment. And then it goes on to name all of the judges, which I'll spare you from. Now, the term used in reference to the loan made by Idin Merodach implies that the lender accepted a share in the property that was bought instead of demanding interest for his money. Hence, it was that, when the estate came to be settled after the death of Ben-Hadad Nathan, it was necessary to pay him off. What the grounds were upon which Akabi Ilu laid claim to the property, we are not told, and the dossier in which it was set forth has not been found. His name, however, is interesting, as it proves the old Western Semitic name of Jacob El, of which the biblical name Jacob is a shortened form, still survived in a slightly changed shape among the Syrian settlers from Babylonia. Indeed, Ikubu, or Jacob itself, is found in contracts of a 10th year of Nabonidus, at the same year of a coppersmith at Babylon, 2,000 years before there had been other Semitic settlers in Babylonia from Western Asia who had also taken part in legal transactions in the country, and among whom the name Yaqub Elu was known. The name had even spread to the Assyrian colonists near Caesarea in Cappadocia, who have left us inscriptions in uniform characters. And among them it appears as Ikib Elu. Ikib Elu and Akabi Elu are alike kindred forms of Yaqub Elu, the Jacob El of Canaan. Death, more especially with an iron sword, was the punishment of more serious offences. Imprisonment and scourging were of lighter ones. Imprisonment might be accompanied by chains or the stock, but the prisoner might also be left unfettered and allowed to range freely through the court or cell of the prison. Whether the penalty of imprisonment with hard labor was ever inflicted is questionable. In a country where slavery existed and the corps vie was in force, there would have been but little need for it. But the prisoner could be released on bail, his surety being responsible for his appearance when it was required. Thus, in the 7th year of Cyrus, one of the officials of the temple of the sun god Sipara was put into iron fetters by the chief priest of the god, but was afterwards released, bail being given for him by another official of the temple. The latter undertook to do the work of the prisoner if he absconded. The bail was offered and accepted before the priests and elders of the city, and the registration of the fact was duly dated and attested by witnesses. At a latter date, a citizen of Nippur was allowed to become surety for the release of his nephew from prison on condition that the latter did not leave the city without permission. The prison is called Beit Kare, the house of walls. There was another Beit Kare, which had a very different meaning and was used for a very different purpose. This was the house of cereals, the storehouse or barn in which was stored such tithes of the temples as were paid in grain. The name is sometimes applied to the sututume, or royal storehouses where the grain and dates collected by the tax gatherers were deposited, and from which the army and civil servants were provided with food. The superintendent of these storehouses was an important personage. He was the paymaster of state officials, insofar as they received their salaries in kind, and the loyalty of the standing army could be trusted only so long as it could be fed. Similar storehouses, of course, existed in Egypt from the age of the 18th dynasty onward. It is probable that the adoption of them was due to Babylonian influence. They gave the king a powerful hold upon his subjects by enabling him to supply them with grain in the years of scarcity, or to withhold it, except upon such terms as he could choose to make with them. The exportation of the grain, moreover, was a yearly source of wealth and revenue which flowed into the royal exchequer. In Babylonia, as in Egypt, the controller of the Granaries was a master of the destiny of the people. Right, and we get to the end of the chapter on Babylonian law. Yes, it is a bit of a shorter video today, but that's just how short the chapter was. And don't worry, we'll make up for it in the next video. So I'll thank my top tier supporters: Dark, Gary, Kimberly, Ember, Ben, Britt, Charles, James, Jeffrey, Aaron, Melissa, Scott, Stark Factory, Wendy, Jaden, Sherry, Jessica, Christine, Sally, Katiana, Christine, Fizarbo, Legitmus, Maverick, Dr. Neuro Nerd, Cameron, Alexander, Nicholas, Daniel, JR, Charlene, and Christopher. Thank you so much for watching, and I will see you in the next video. Good night, everyone. Lots of love to you all.